Okay, good afternoon everyone. Today we're actually privileged to have Tim Sullivan with us. He's a man of many talents, and he's going to be talking to you today about arbitration, adjudication, dispute boards, possibly neutral evaluation as well, and expert determination possibly if there's still time available. Look, just a brief overview about Tim. I think that you may have actually already seen what was on the Moodle site in relation to just some information about Tim's expertise. He's a Life Fellow and past president of IAMA. He runs his own business, basically regarding dispute resolution and dispute prevention, and that business is called Contract Administration. He's a member of LEADER. He's been on numerous boards. His background, from what I can tell and from my conversation with him, seems to be in building and construction, but also he has done enormous amounts of arbitrations, adjudications and the like in a whole range of matters. And I think the other thing that has struck me with Tim, and this is the first time I have met him, but I've spoken to him over the phone a number of times, is that he certainly seems to be very interested in education, mentoring and training of young people and of people in this particular area. So on that basis, let me introduce Tim Sullivan to you. Thank you.
Thanks, Doris. The next couple of hours that I'm here for is your time, not mine, so you lean on me or take it wherever you want to go. What I want to address today is some other aspects of ADR that your other lecture sessions haven't dealt with. The things that I'll mainly address today is arbitration, I'll address adjudication, and I will also address dispute boards. Now, some of those will be familiar to you and some will not be familiar to you. Could I suggest that if you're at all interested in ADR and in a career in ADR, it's absolutely a wonderful time to be getting into things like arbitration, adjudication and dispute boards. The reason being that dispute boards in Australia, I think we're presently up to about 46th dispute board in Australia. It's not a big number. But big dollars they're spending in those projects. But there are about 30 dispute boards that are presently being worked through to be added to that list. So it's growing exponentially in that field, and it's a good time if you're going to be assisting clients or working with people in the industries where there are big infrastructure projects, and you could be at any stage in the process, then it's an ideal time to be one of the first kids on the block, if you like, to know what dispute boards are, how they work, how to get the most out of it, and how to put the best into it. But also, we're talking about arbitration, and that's also a good time to get into arbitration because since the mid-80s, 1984 and onwards, we've had uniform commercial arbitration acts throughout Australia. And for various reasons, they didn't perform fully to expectations. And now what you've got in every jurisdiction in Australia, and also in our federal jurisdiction with the International Arbitration Act, we have new commercial arbitration acts in every jurisdiction except one, and that's the Australian Capital Territory. The only reason that it's not in the ACT at this stage, they just haven't got around to it. The commercial arbitration acts, the first of them came into effect in 2011 in New South Wales, the new Commercial Arbitration Act, and then all of the other states have replaced theirs in 2011, 12 and 13. So it's very much new ground, and a lot of people have no idea how the new Act works, even as experienced adjudicators, and I put myself in that category. We are still very much on a very steep learning curve as to how this new legislation really works, because you don't know how legislation works quite often until it's really tested in a factual situation, until you get two lots of learned people coming before you, or three or four, depending on how many are involved, and testing that legislation to the umpth to suit their own interests. And quite often you don't know the answer to an issue because you don't know the issue until it arises. So it's a really good time to be getting into arbitration, either to assist parties or to be involved, if you like, as a dispute resolver yourself, because the training is available to people like yourselves. And we do need younger people. I mean, there's too much testosterone in a lot of our institutes, and there's too many old people, like myself. I guess I can say that. Somebody else may not be able to refer to old people, but we're all getting older. And whilst experience is a great thing, fresh minds are quite often a good blend to put with it. And the third thing I'm talking about is adjudication. Now, adjudication I'm talking about mainly, but it's not the only field, but adjudication in the building and construction industry. Every state and territory in Australia now has an act to deal with payment disputes in the building and construction industry. In New South Wales, there was the first one. It's a 1999 Act with effect from year 2000, March 2000. It was the first cab off the rank in introducing legislation which it had picked up from England and modified severely. And it's essentially to sort out progress payments on construction projects. Now, they might be progress payments ranging from sort of $1,500. The biggest one that I've dealt with is a $107 million progress payment. So we're talking about a big range of matters. You've only got one piece of legislation, one size fits all. It's a process in which the adjudicator has 10 business days in which to make a decision. So if you've got 30 boxes of documents, just reading them is one hassle, but then encapsulating a fully reasoned written decision for the parties, knowing full well that they're going to pore over every word that you say to see whether or not they can challenge that decision in a court, is a pretty daunting task. With a bit of experience, it comes a bit easier. But we put a lot of time into training people to be adjudicators under that process. Why is it a good time to get into it? Because all of the legislation around Australia has been evolving. New South Wales introduced it in 1999 with effect from 2000, but it's also gone through another quantum leap in adjudication litigation, the adjudication statute in New South Wales in 2003, and the other states have followed. Western Australia and Northern Territory have gone in their own direction with different type or different style of adjudication processes, but they have all, right up till 2011, with effect from 2012, these statutes are all new. So if you were getting out into that field now, you'd probably know as much as some of the experienced partners in the law firms, because quite frankly, they're still doing it the way they did 10 years or 20 years ago. And if you come to it with a fresh mind and say, have you thought about a security of payments claim, it's a whole novel approach. And so that's the sort of things that I want to address today. But what do you want to address? I guess that's the thing. You might want to take me down the line further on the mediation process, though I think Rosemary has covered that as much as we would want to cover. I do quite a bit of mediation. Then expert determination is another thing that I do, and early neutral evaluation, expert appraisal. So there are different processes. Bear in mind that dispute resolution alternatives, with litigation you don't get a choice. If somebody sues you, you've got no option but to either pay or go to court. Essentially that's what it is, or compromise. With arbitration, if somebody wants to take you to arbitration, they can only do that if you have entered into a commercial arbitration or an arbitration agreement with them. That used to be quite a stringent signed up type of clause in a contract or an express arbitration agreement. With the new legislation now, they've identified different ways in which you could enter into that arbitration agreement. There are statutory-based arbitrations, particularly court-referred arbitrations here in the ACT, and other types of arbitration. We won't touch on those today because really what we're talking about is a consensual process where parties have entered into an agreement to refer their disputes. If they arise, they'll refer them to arbitration. So it's consensual in that sense. After that, everybody is bound by the arbitration agreement, and then they're bound by the relevant legislation in their state, or if it's an international matter, they're bound by the International Arbitration Act, which is a Commonwealth Act. With expert determination, dispute boards, early neutral evaluation, expert appraisal, they all arise out of agreements between the parties to proceed in that way. Nobody can force any of that on the parties. Adjudication is a little bit different. If a claimant puts a claim in relation to one of those pieces of legislation, it's like litigation. You have no choice. You either pay it or dispute it. And if you dispute it, you can be dragged through adjudication, whether you like it or not. And it's not very friendly legislation to respondents generally. It's weighted very, very heavily in claimants' favour. The first thing that I want to talk about, and please stop me at any stage, I don't necessarily want you to save questions up till the end, and the students in Victoria, if they've got questions, Doris will pass them on to me. But so if you've got questions along the way, just please stop me at any stage, or if you want to take it in a different direction, or if you think I'm boring, tell me and we'll take it somewhere else. Let's start with commercial arbitration. And commercial arbitration, as I said, it has been governed in the ACT, is still governed by what were referred to as the Uniform Acts. Now, the Uniform Acts were around since the mid-1980s, and they covered the domestic commercial arbitration in Australia. Now, the Acts there were almost inevitably known. There was only one difference. They're all known as the Commercial Arbitration Act, and it's very important as law students to understand that nearly every case that you will read and every reference and every article that you will read and pick up about arbitration is going to be written about arbitration as it was under those acts. And the views of the court and the views of those authors are going to be based on that legislation. The legislation now is vastly different. And so you need to be very, very careful when you're looking at legal precedent to make sure that you understand what was the governing legislation at the time. It's also very important to note what the governing legislation was. You want me to smile or just move over? Thanks. With the governing legislation, for example, I just did an arbitration for a gold mine in the Sullivan Islands, and there were parties in London, Brisbane, Sullivan Islands and Western Australia. But the parties in their original contract had entered into an arbitration agreement in which the Western Australian Act applied. Now, if that ended up as a court matter, you would have to dig a little bit deep and understand why some of the procedures and processes and challenges may have run the way they did, because ordinarily people might think that would have been an international arbitration. I thought it was. Parties said, no, it's not. Just before the hearing, they changed their legal representation at the upper level for presentation, had a QC for each of the two groups of parties, and the QCs said, we think this is an international arbitration. I said, I think so too. But anyway, the thing is that had that gone on to a court matter, you would have to understand what the governing legislation is. So just that note of caution, if you're reading, understand what the governing legislation is. Because, for example, in New South Wales, a non-legal person, in other words, a person who doesn't hold a practising certificate, that could be a solicitor, for example, from another state, it could be an engineer or what have you, they are authorised to represent under the Commercial Arbitration Act without penalty of infringing the Legal Profession Act, because you have to be legally qualified to do legal work. However, in Western Australia, that restriction is entirely different to what it is in every other state in Australia. And I just quote that by way of example, that you just need to understand what it is. So you had 7 arbitration acts up until now, the Uniform Acts, and the ACT, if you're still reading that and you looked, I had a case which was an arbitration, I forget what year it was now, but I found heavily against the respondent in that matter. I think there were 7 or 8 parties in it, and the matter went for enforcement in the court, and the court upheld the decision at that stage. It was 11 years after I delivered the award that there was an appeal on it, and ordinarily they wouldn't give leave to appeal, but what had happened is the registrar in that case had actually written to the losing party and said, you've got 14 days in which to lodge an appeal. He should have said you've got 28 days. So when it went back before the Chief Justice said, look, we got it wrong, and therefore we have to give leave to appeal. So he heard the appeal and still downed it anyway. But It's just interesting. That's Maunsell and Partners, if you want to read. Oh, Maunsell, it was the name of the arbitration, and it's in the Supreme Court. And you can just see how the courts deal with arbitration. And back then, they weren't as friendly to arbitrators as they are now. The courts looked at arbitrators as competitors. And if you look back through history for the last 500 or 600 years, you'll see that tension between the courts and the private dispute resolution processes, is that the courts felt that commercial arbitration was taking matters out of the court, and so that was stealing their livelihood. But there's been a greater maturity where, even in the ACT and the current law, they can still refer a matter to arbitration. In other jurisdictions now, they'll actually refer it to a referee, and what it is, the referee has certain powers of the court rather than acting as an arbitrator. But you find now that the courts are very, very supportive of arbitration. In fact, in places like Victoria, the Supreme Court appointed Justice Clyde Croft as the specialist judge for commercial arbitration. That's his specialty in dealing with it. So if there's an appeal or a process or an interlocutory order that an arbitrator can't give, it'll go before Clyde Croft if you're in Victoria. In New South Wales, the Chief Justice at the time, Jim Spiegelman, was the one who was the catalyst for bringing the new Commercial Arbitration Acts into Australia, and the councils of Attorney Generals were the ones that put their heads together to say, okay, how can we make that now that it'll apply in all jurisdictions across Australia and to our International Act, and they did it. But that was because the Chief Justice of the Supreme Court in Sydney was such a strong advocate of commercial arbitration. So it really is now, the courts will, and the new Commercial Arbitration Acts, all lean towards upholding arbitration. If the parties, because don't forget arbitration again, we go back to it, there must be an arbitration agreement between the parties. And so what the attitude of the courts is now, well, if you agreed to arbitration, you're stuck with it. It may not be perfect. The arbitrator might have got a few things wrong. It may be, not as nicely expressed if it was there by a very learned counsel or a very learned judge. But it's, you asked for arbitration. You asked for how the arbitrator was to be appointed. You got that arbitrator. This is the decision she gave. This is how we're going to enforce it. Unless there's very, very good grounds, we're not going to allow an appeal against it. And there has to be very good grounds. There used to be, the guidelines used to be that it had to affect the rights of one of the parties substantially, and it also had to affect the rights of the commercial world generally before you could have a right to appeal. It's not quite the terms that they were used. They used to call them the NEMA guidelines. They did apply them here in the ACT. If you look at that case on Parliament House Construction Authority, it's one of the few long-winded cases here in Australia. ACT, what were the grounds on which the appeal was allowed? The appeal was allowed and then downed. So that's the way it used to work. Now, the new Commercial Arbitration Act has really restricted the powers of the courts to interfere with the processes. Why did we have new legislation? Essentially because the old legislation wasn't delivering. It was out of sync with the model law or UNCITRAL law. It was also because there was a decision of the High Court in Esso versus Plowman regarding confidentiality. The main attraction why people would go and pay for their hearing rooms, pay for their transcript, pay for private arbitrators, pay for their time to read the matter, pay for their time to hear the matter, pay for their time to sit at home in the dark writing their award, which comes to a lot of money, quite never enough, but it does, it comes to a lot of money. Why do parties go down that private line and spend all that money? And the reason being, one of the main reasons is that it's confidential. Whereas the moment you go to court, then it's there for all to see. It's public knowledge. Unless you get some sort of suppression order, as you may get in more private matters, everything becomes public, including people's details about tendered prices, what their novelties were in the ways in which they were going to approach projects or the products they were going to use. That all comes out if it's in evidence, and it may end up in the judgment, it may end up just in transcripts, it may end up because it's been tendered before the court that some people will argue and it's public anyway. The beauty of arbitration is that it is private, and there's no argument about it being private, but the question is whether or not it is also confidential. And in the Esso Ploughman case, there was some very, very commercially sensitive information, and the High Court says no, public policy at that stage is, well, it should be, there's no reason why, if you're going to dispute it, it shouldn't be available to the world at large. So there were a lot of very private pricing commercial information that was allowed out by Esso. What happened because of that decision was that international parties in particular would not put Australia into their commercial arbitration agreements as the seat of arbitration. We just lost that for years. And that was in 1995, that Esso decision, and almost immediately international arbitrations in Australia dried up, except those that were in existing agreements, because people then started to look to places like Singapore, Hong Kong, London, New York, to see that'll be the seat of arbitration. So that one Esso decision was enough to turn it on its ear. What the new Commercial Arbitration Act now, it embodies and embeds into the legislation the confidentiality provisions, and you have to contract out of them rather than contract into them. Whereas in the old process, they said, well, look, if you've agreed that it'll be confidential, but otherwise it's not confidential. Now they've reversed that particular position. So they're the sort of advantages that's moved into this century, and that's why it's very important for people like yourselves now to understand that arbitration is a whole new thing. It is a much more attractive process than it used to be. What else makes it attractive is the procedures. Under the old processes, the Commercial Arbitration Act doesn't, it's not prescriptive as to the procedures to be adopted. And so people come up with rules, like the Australian Centre for International Commercial Arbitration has one set of rules, the Institute of Arbitrators and Mediators Australia has a set of rules, Chartered Institute of Arbitrators has a set of rules. What's another one? The ICC in Paris, they have a set of rules, and people adopt these rules to run their arbitration because of the holes and the gaps, if you like, within the Commercial Arbitration Act. And with that procedures, what happened essentially, because there was no legislation that empowered the tribunal, if you like, and empowered the parties, the arbitration was essentially hijacked by the legal profession, and no disrepute to them. I mean, if you hire a professional from the legal profession to do what they will in your interest, they will pull every string that they have to, particularly where there's a lot of money or a lot of reputation at stake. And so when you go to an engineer, for example, you'll get an engineering solution in most cases. If you go to an architect, you'll get an architectural solution. If you go to a lawyer, they'll be looking for a legal solution. And that will be the emphasis that goes forward to the tribunal that's sorting out the matter. Well, what was happening with the arbitral process is that lawyers essentially had the process mimic court procedures. So you would end up with a process kicking off with a statement of claim, and then a statement of defence, and then a statement in reply, and then you would have statements of evidence in chief, and statements of evidence in reply, and then statement of evidence in support of the cross-claim, and statements of evidence in reply to that, and then further statements in reply to those. You would have expert reports that come in, and experts report in reply, and then experts reports in common. You would have processes like discovery and inspection of documents. The whole process got to be something which, instead of having something you could sort out in a few months, an arbitration could in fact take 12, 18 months, sometimes longer. And it was not unusual for the legal profession to take the full advantage of the lack of knowledge and experience of the tribunal. And so they would really test people on the laws of evidence and things like that. And, you've done your law, you know how tricky laws of evidence can be. Well, wait till you've got two parties arguing tooth and nail for several $1 million over whether or not this particular document is admissible, and you have to go through all the tests and everything else, and it wasn't discovered, and it was discovered, and it hasn't been authenticated, and whether it's relevant, whether it's not relevant, what is the issue it's relevant to. I've seen debates on one document take 3 days in an arbitration. But mind you, I've also seen it in court, but it never gets reported that way. The judge ultimately just has the power to step in, if you like, in a court and says, well, get on with it, it's the thing. And I'm sure ACAT does the same sort of thing with their med-arb. They step in. You don't sit back and allow these things to rabbit on. But under the Uniform Acts, the arbitrators didn't have that amount of control or power, neither did the parties. What the new acts have done, they've now empowered the parties and the arbitrator to have a lot more control on how they want the matter dealt with. They can set very strict timetables, or they can fit a loose timetable depending on how they want to run it. They can have a very, very closely defined dispute, or they can have it broadly defined. They can have things like a chess clock hearing, and that's where some of these matters, you can have one counsel can take several days to make a presentation that really, if you boiled it down, could have been done in 15 minutes or 2 hours. No disrespect, they're there being paid by their client to do the best for them. If they think that's the best, that's what they'll do. But now you could actually say, well, what we're going to do, we're going to allocate the time in this arbitration or in this hearing in this particular way. You might also do, these days, there are a lot of novel approaches with electronic assistance in hearings. You can agree procedures for that now. A lot of my matters now, I don't see too much paper. Actually, I do see a lot of paper because I tend to still print it. Great saving, I know, but but in reality, what happens, like that Solomon Islands matter, we ended up with 220 boxes of documents, essentially, that were at the end of the day. Originally, it was agreed between the parties that it would be done electronically, and it would only the primary documents would be required to be provided in hard copy. Parties took it that they were all primary documents, and we just kept getting truckloads of these things. You know. At the end of the day, the bill was quite high just in having somebody come to take them away to dispose of them. The other thing that's now embedded in the Act, it was implied in the Act before, is the requirement for natural justice. It's referred to in the Act as procedural fairness. That was always an implied that you had to afford the parties natural justice under the old Act, but under the new Commercial Arbitration Acts, there is a requirement to afford natural justice. If you look at the Act, the parties must be treated with equality. Each party must be given a reasonable opportunity of presenting the party's case. That was always implied before, and you would say, well, if you wanted to appeal an arbitrator's decision in the past, and that's why I say be very careful when you read the cases on how you might overturn an arbitrator's award, they would do it generally on the misconduct of the matter. And it's not misconduct by misbehaviour, it's misconduct in the sense that you didn't conduct the matter either in accordance with the arbitration agreement, or you didn't give the parties, afford them that procedural fairness. So you've got to give things like, when you're having a hearing, you have to give the parties sufficient advance notice of any hearing. That's now embedded in the Act. You can't just put it on them at the last moment. Now, things move quickly in the commercial world these days. In an adjudication, for example, I might call at 10 o'clock in the morning for a submission to be with me by 3 p.m. You'd think that's not possible. I have to be careful that I'm not denying them natural justice, so I won't make that an order, I'll make that a request. I'll also make it clear that if it's not sufficient time, please tell me what time it is, having regard to the time constraints. In an arbitration, similar sort of considerations come in. I can't ask for the parties to give me a submission in a time in which they just cannot get instructions, cannot get advice, and cannot physically get the thing to me. So that's why you need to be looking at things like procedural fairness, and the Act now embeds that sort of thing into it. The other thing that you look at are the range of orders that an arbitrator can now give, and they're actually interim measure orders that an arbitrator may give. For example, in litigation, it's not unusual, particularly for a claimant, to be completely impecunious, and the other party to have sufficient funds to run the matter, and that's sometimes a big advantage to the person who doesn't have any funds. We always think of the disadvantage the other way, but the real disadvantage is to the respondent in that case. If they've got a lot of money, the other party's got nothing. The first party's got nothing to lose, providing the other one's going to pay for the dispute process at the end of the day. That's pretty daunting, say, for a BHP versus Mrs. Smith, because Mrs. Smith might not have anything, and BHP will never get the money back out of her if they win, lose, or what have you. And so the law does allow for courts to order security for that party's costs. So if you've got, and they'll look at it and say, no, well, we think Mrs. Smith has a right to bring this litigation, although she doesn't have the funds, etc. It's in the proper interests of justice, etc. And we won't order security for costs. But if the same Mrs Smith has just run 13 cases against BHP and lost every one of them, BHP might be getting sick of it by now and say, look, if you're going to keep going down this path, we want security for costs. And the court will look at that, and probably in that case, the extreme case, they might say, look at it favourably. Arbitrators didn't have that power before unless the parties agreed to give them that power, which sometimes they did, but not very often. And so what the new Act says, look, we don't want the courts interfering. Under the old Act, the courts had a role at every stage in the arbitration process, and it just bogged arbitration down. You could bog an arbitration down for 3 months or 6 months while you got a slot in the court to deal with some interlocutory matter, for example, as to whether documents under a subpoena should have been produced. But now all of that is transferred to the arbitrator to make that decision. If she decides that that's the way it is, you live with it. The only thing is some of that you can appeal back to the courts, and they will enforce it or not enforce it, but there are very strict limitations on what the court can do to interfere with that interlocutory decision of the arbitrator. The challenges to an arbitrator under the old Act were the grounds were fairly limited when on the face of it, but in reality you could dress anything up really to fit it within the grounds. I mentioned misconduct by the arbitrator. That's misconduct, for example, allowing evidence in that shouldn't have been allowed in, or discarding evidence that should have been considered, or the exercise of undue influence in relation to the arbitrator, where one party has had undue influence on the arbitrator, or if the arbitrator were proven to be incompetent or unsuitable. Now, that even if a party had agreed to the appointment or even nominated the arbitrator and the other party accepted it, that doesn't say that you can't allege later that they're incompetent. But what the new Act does, it still allows those processes and a few more, but it puts a very strict time limit. You can't say, oh, okay, now I've lost, so I'll look for all these matters on which I'm going to challenge the award. If you've got an issue, for example, with misconduct, you've got 15 days essentially in which to bring it. That's probably dressing it up a little bit short, but if you read the Act, you'll see that there are time limits in which you can invoke the power of the court. And if not, then you're taken to have to live with the matter. So they're the sort of things that that you need to look at now when you're reading any cases, even S.O. Ploughman, things like that. You would have to be very, very careful as to how you do it. The conflicts of interest are always something that's uppermost in a dispute resolver's mind. Even if you're sitting on a tribunal or a court, you're always conscious, if you're the decision maker, to make sure that there's no conflict of interest, or if there's the potential for the conflict of interest there's a full disclosure to the parties, and the parties can make up your mind as to how they proceed. And in these processes here, in that Montal case here in the ACT, which was appealed online, one of the grounds of appeal there were bias on the, no, not bias, was the arbitrator in that case had a conflict of interest, or it could have been bias, I forget the case now, it doesn't loom large in my mind. But the challenge that was put, the court threw it out, and it was because of the disclosures that I had made early in the process. So it's about open, transparent, being transparent, if you like, in the process, whether you're mediating, arbitrating, whether you're sitting on a tribunal, about making sure that the parties are fully aware of your past associations. I used to operate out of Canberra for about 20 odd years in this field, but it's such a small pool here that I had appointments from the Supreme Court while I was away on a trip. And when I got back, I had 4 appointments, and I was conflicted with all 8 parties. And I thought, it's time to move to Sydney. And now, because I operate all around Australia, I end up with the same parties coming back time and time again, and you have to make full disclosures on it. For example, I do matters where I'm arbitrating or adjudicating and a government department's involved, and then I'm doing another matter where they're also involved and another matter where they're also involved. And so everybody has to know exactly what I'm doing, where, and etc. Again, it's all about disclosure. Have a look at the new legislation. If you're at all interested in arbitration, do have a look at the legislation. Pick up any state in Australia other than the ACT and just read that legislation. There are various old rules of court. There's actually the paper that I've taken a lot of notes from is, and you can make a note of this if you like, because it's not a long paper. It's an article written by Professor Doug Jones. He's from Clayton Utes, very learned in the field of domestic and international arbitration. He operates out of Sydney, Melbourne and London. His article is called The Revival of Commercial Arbitration in Australia. It's an article from 22nd of March 2011. I've given Doris a couple of my notes, so she'll have that reference in there on page 2, Doris. And you'll see there where Doug Jones then compares the old Act and the new Act, but then he talks about the benefits of arbitration. Now, a lot of the criticisms of arbitration in the past were that it took too long, it was too expensive, it was just litigation by another name, etc. And what has happened with the new Commercial Arbitration Act, their intention was to put it back to a commercial arbitration where you could style a process to suit the dispute, to suit the parties, where the parties had more power and control over the whole process, where the courts had less room to get involved. The grounds of appeal or the grounds of challenge or the ground of involvement from the courts were severely limited. And so that seemed to be what's working with those few matters that have gone through the courts. The courts have been very, very supportive of the new legislation. There was a challenge into the High Court on the constitutional grounds as to the legitimacy of the New South Wales Act, and that would have been the same throughout Australia, and it's been upheld that it doesn't offend the Constitution. I think Section 109 of the Constitution was one of the grounds, but there were other grounds as well. Have a look at the interim protection measures. There were four grounds on which arbitrators can now order protection orders. They could not order protection orders before unless the parties agreed to it. Generally, you find one party doesn't. Have a look at confidentiality, which is the real big thing, the real plus for arbitration. And then have a look at the greater flexibility and autonomy that the Act gives, particularly if you want to have a quick look at the 1986 or 1984 Act from that same jurisdiction. Have a look at the 2010 or 2011 Act in that jurisdiction, and you'll see how the flexibility and autonomy is built into the rules. That's about all I really want to say on arbitration. Remember that it is a new dawn in commercial arbitration right now, so it's a good time to be getting into that side of ADR if you're at all interested. Remember, commercial arbitration doesn't go just in the field where I mainly operate, which is building and construction matters, but I do a lot of other matters too. I do a lot of mining matters, I do a lot of rail matters, I've done de facto relationships matters, those type of things. Fortunately, I don't do them anymore. A few bad experiences were enough, I thought, including both parties threatening to shoot me before the matter, and Jeffrey Miles was Chief Justice here at the time, and he said, I'm going overseas for a while, you can have the sheriff and you can have my court for the duration of the hearing. It was much appreciated. So the field I mainly get involved is either professional matters, where the professional misconduct, or the ethics matters, and providing they're justiciable. And the other main areas I get into are infrastructure development, building, construction, rail, shipping, shipping facilities, that type of thing, and mining. All right, so that's about all I want to say on commercial arbitration, but I'm happy to take any question before we have a quick break. We're coming up to about the right time for a break, aren't we? We'll have a quick break shortly. Have you got any questions that anybody wants to ask at this stage?
So from what you've described of how the courts are supporting arbitrators, it seems like it's harder to appeal from arbitration than it would be just from a normal court matter.
Yes.
Is that right? So
Yeah.
do you think that would turn off some of like the BHPs of the world from engaging in it?
No. It's particularly because of that. The question for those who either couldn't hear it or the people online deals with the attractiveness, essentially, of arbitration, or lack of it, because courts make it harder to appeal against an arbitrator's award than against a decision of a court. The attractive thing about arbitration is it's final and binding, and the parties, even losing parties in litigation, generally want it over with. They don't want it to go on and on and on. For every bit that goes on, I mean, litigation costs millions of dollars. Even on relatively small matters, it costs hundreds of dollars, thousands of dollars, or hundreds of thousands of dollars. And parties really, even when they lose, they don't like the result. But in most cases, they don't go on to appeal the matter because it's maybe only another 50,000 or another 100,000 to roll the dice again. They're just shot of it. So even the BHPs of this world, they like the finality of arbitration. And particularly now, that what it is, there are sufficient grounds there if there's truly is misconduct on the part of the tribunal, the arbitral tribunal, as there was in the sea containers case about 5 years ago in New South Wales. The court will step in. The court will roll arbitrators. They will roll the cases. They won't put stupid decisions through. They won't put decisions through that have been improperly procured, and they won't back up arbitrators who are just they're not concerned with whether they're wrong or not. That's not really a relevant consideration. But if they haven't procured the result in the proper way, then they will roll them. And so that's with the courts. If you look at it, the courts are generally fairly reluctant to roll a lower court. You look at the appeals against magistrates. For the hundreds and hundreds and hundreds of cases that go through the tribunals or through the magistrates' court, there are not that many cases that really succeed in an appeal later. And there are not many arbitrators' awards that are appealed at the end of the day. People tend to leave. For those few that go through, quite often there are genuine grounds for it, but then the courts, as you say, will be reluctant now under the new legislation. The grounds are narrower, and the courts will be reluctant to interfere with it. But I don't detect in any of my clients and the people that I assist in that a reluctance now with the new Commercial Arbitration Act to prefer arbitration over litigation. If you go back 5 years ago, the commercial contracts and construction contracts were being written up with dispute clauses that ruled out arbitration altogether and went straight to litigation. Even in those circumstances, some parties, when a dispute arose, said, well, look, let's not litigate it. Why don't we enter into an arbitration agreement after the dispute arose? And they still go to arbitration on that basis. So parties are still, in a lot of cases, preferring it, not all cases. And it's up to people like yourself as to look at the benefits of going to arbitration or not going to it, and advise your client accordingly. And it's not the answer in every case. There are benefits. There's an upside and a downside. Yes.
Do you think that the focus on confidentiality could sometimes amount to a lack of transparency? And if so, do you think that that has any implications for the wider legal community?
Questions about confidentiality and whether it has implications for the wider legal community. Confidentiality, if the parties wish to, they can waive that confidentiality. It used to be that they had to enter into an agreement for confidentiality. I think confidentiality is essential in many commercial matters. For example, you don't want everybody knowing what your tendered rates and prices are for jobs. You don't really want your technical know-how being published to all your competitors. And that is one of the problems if you don't have confidentiality. I don't think it creates hassles. I don't think it creates any problems with regarding transparency, because even with the confidentiality requirements that are in the Act, you could still disclose them in the court if you were going to appeal the decision and the judge thought it was relevant. If she said, well, we think that it's relevant here in this particular matter on these grounds of appeal to make this disclosure, then we'll disclose it. But courts and tribunals and arbitrators and adjudicators these days do their very, very best to depersonalise, or what's the word these days? But anyway, they depersonify and take out of their judgments personal details of people. For example, it might be Miss Smith, but they won't put in the decision that she lives at 16 Chalmers Street, The Rocks. I mean, that's not going to be published to the world. It might be Miss C or it might be Miss Chalmers, and they live in Sydney or they live in New South Wales. They just won't say it. If it's important to say she lives at The Rocks, they might say, look, she lives near the subject development, if that was the problem. They'll depersonalise it in that way. Anonymisation, I think was the word that you... Redact is one thing if you're then publishing the document later, but the way that Jim Spiegelman wrote about it, and they have rules in the Supreme Court in Sydney, they have the anonymisation within judgments. So when you're writing it, you may have to disclose it behind the scenes, but the confidentiality, there are times when, for good reason, public policy being one of them, that you may be able to lift that veil of confidentiality. It's not so that you can keep things under the table, it's so that you can have commercially sensitive stuff. Or it can be that the parties, sometimes matters come up regarding parties' behaviour in the conduct of a contract and whether or not there's been some sort of misconduct on the part of the people running the job that's led to a breach of contract. And it might be that people don't want all that dirty linen out there. They want the arbitrator to know so a decision can be made, but they don't want it published to the world at large. Any other questions?
Can I ask, is arbitration then generally seen as being quicker and cheaper than litigating?
Now or then? And this is the question, the comparative costs of arbitration litigation. Arbitration has the potential to be much quicker and cheaper. Having said that, it was, under the old acts, generally dearer, and it was generally took a lot longer and a lot more work on the part of the parties to get to the end of an arbitration and still face the intervention of the court at the end of the day. So all of that went on. Under the new legislation, that has been improved considerably. When the courts knew that they had problems, like very long waiting lists, New South Wales, you had to wait a few years to get a case on, going back some time, they brought in things which were called their Part 72 rules. You could refer matters to an arbitrator, but you could also refer them to a referee. And I did a number of references where the court actually appoints the referee and you sit as an officer of the court and you hear these matters. A hearing might take 3 months. They're not necessarily small matters. But what they did, they reduced their waiting lists on the court, or their court times. They got the matters out of the courts and they got their timetables and case management processes in order. So it got to the stage then when court processes in New South Wales were a lot more efficient time-wise and generally a lot less expensive than private ADR processes. Now it's swinging around the other way. Courts are still very efficient, which is great. They haven't lost any of their ground there. But things like arbitration with the new Commercial Arbitration Acts, the processes that arbitrators have more power and the parties have more power, they are now having much slicker processes, and they cut out a lot of the gumph, if you like, that would normally come with the rights under the Uniform Civil Procedure rules, although they'll refer back to the rules when it suits them. Thanks. Yes?
Just a question about the type of people that seek arbitration. So clearly it's in a lot of ways, it's a lot of companies in business transactions. Are there other parties, other types of parties that would seek, like individuals and
Yes.
do they benefit from arbitration as much as companies do?
Yeah, so the question runs about the type of party. I'm only repeating the questions because of the people online may not hear you, but it's about the type of people who may be parties to arbitration. The first governing principle is that, or the first governing part of the law is that there must be an arbitration agreement in writing. Now that could be exchange of emails or what have you, but the thing is there must be an agreement between the people who are party to the arbitration to actually submit to it. Now, it does range from individuals, sometimes individuals against individuals, sometimes government bodies against government bodies, sometimes between state government against another state government, sometimes a state government against a federal government, and sometimes private companies against private companies. There's a whole range within there. And the beauty of the Commercial Arbitration Act, the way it is now, you can style a process for that type of matter. And you may want the bells and whistles of a full court-style procedure for that upper-end dispute, as much for the arbitrator's assistance as for the parties. But for the lower end and the smaller dollar value type disputes, then you may have a different process. There's two other types of arbitration I'll just mention to you. AU domain names, so Australian domain names. So if you've got something .com.au or .net.au, if you go through Melbourne IT or any of the ISPs, they all have a disputes procedure in there. So somebody might be using a name that's remarkably similar to yours. You can challenge that. And to challenge that, you go through a process, an AU name dispute resolution process, which I was heavily involved with when that was set up, and we did a lot of the procedure. It's a very, very inexpensive process. It generally costs $1,500. The arbitrator makes no money out of it, but it's an arbitration, if you like. There's also investment disputes, particularly international investment disputes, where China might lend, $360 million to somebody at Albury to set up a paper mill. That'll be an investment dispute, and that'll be under an international commercial arbitration, but under different UNCITRAL laws, model laws, etc., that apply there. So you've got the whole spectrum of, neighbour against neighbour is not unusual for parties properly advised and assisted to agree to go to arbitration on that, to say, look, we can't resolve it, we've tried mediation, we don't want to go to court, we still want to be heard, can we involve some process? So they'll meet with a potential arbitrator, discuss potential process and say, well, that's fine, that's how we want to go. The arbitrator then must obtain their agreement in writing between themselves that they want to refer the matter to arbitration and that they want her or him to sit on the arbitration, and then they might have a conference then as to how the arbitrator is going to get paid. That's the bit I concentrate on. And then what the processes will be, etc. And then the whole process flows from there. And that'll be a very short, sharp process. I've had arbitrations. In fact, I had coffee with my ex-wife this morning because I had another dispute matter here, and I hadn't seen her for quite a while. And she said, oh, the church out there at such and such still speaks highly of it. I said, what was all that about? And I remembered then what it was. There were 30-odd disputes on the construction of the church, and that was a church body against a builder, not a big builder, but I think the construction contract was probably $100,000, $200,000. And for these 30 disputes, they started to exchange all this paperwork. And I said, look, it's going to cost you more at the end of the day to run it this way than any other way. Why don't we actually meet on site? And you can tell me each of the problems and we'll have a look at them as we go through. Those that we have to go to a hearing later on, we will. Those that we can resolve on site, we resolve on site. And of the 32 disputes, we resolved all of them on site on that particular day. And I think it'd end up costing each of the parties about $1,000 or something like that. Had it gone down the other process and different styles, it probably could have cost $30,000, $50,000, $60,000. So that's why, and now we have even greater strength and flexibility and autonomy than we did before. So, yep.
What happens if during the course of an arbitration evidence of criminal behaviour comes to light? Are you obligated to report that to any authority? And especially in an international arbitration, if it turns out to be against one country's laws but not against the others, what happens then?
Well, the new International Arbitration Act addresses that in part for international arbitrations, and that would be something at the end of the day which might provide a ground of appeal on the basis that it's not in the public interest. For example, if you had an illegal contract, for people smuggling or something like that, how would you enforce it? And in that particular case, it might be against the public interest to enforce that contract. However, I've had precisely that situation where there were 14 parties in an arbitration, and they were all from the one European country, and they were doing deals over a number of years to, I'll do this for you, you give me the bobcat, I'll pay you 50 grand, I'll employ your son for a while, these sort of deals, and none of it recorded. And so when it all came off the hook after a few years and who owed who what, it was, there's nothing wrong with those sort of agreements. But the sort of things that started to come out in cross-examination was, Mr Z, you're claiming $55,000 for the hire of a backhoe. Yes, yes. Do you own a backhoe? No. Oh, well, what happens? Oh, I own a bobcat. Well, did you own a bobcat at the time that this money was being charged? No, I only bought it just recently. So this was going on with a whole fabrication of stuff. And they said, well, what was it about? Oh, well, really it was about, he wanted to borrow $55,000 from him. I said, that's fine, but I wanted to charge him as a backhoe so I could claim as a tax deduction. This is in evidence, right? That's fine. So the bloke said, oh, well, you were falsifying your tax returns in this regard. Oh, yeah, that's what the accountant told me to do. The accountant's in the room and shrunk away to nothing. The barrister's shrinking away to nothing. And he said, well, have you ever invoiced for this? He said, oh, no, because he said, I only want to declare that as expenditure. I don't want to declare it as income. So this went on and on and on. And my obligation there, I didn't need to go too much further to know that it was illegal. Ordinarily, the legal representative of a party can't speak to their client while they're under cross-examination. But in that, I interrupted proceedings, and with the leave of the other party, I suggested that the party be taken outside and talked to about what admissions they make and what the effects were, etc. So I don't know the full definitive answer, but I suspect that I'm supposed to bring it up. In a mediation, for example, if it's a mediation and there's matters of illegality and things like that, then I'll stop the mediation at that stage, because I can't be party to hiding that and having an agreement to set all that aside. The law is the law and you can't interfere with it. In an arbitration, the main thing for the arbitrator is to make sure that there is transparency in the award at the end of the day. If you were relying on something that was illegal, you would generally draw, if the parties are represented, you would draw the party's representatives' attention to it, and they're not smart enough. Mind you, those people still came back in and were making worse admissions than that, even after being warned and being stopped proceedings, take them outside. You need to talk to them about that. As I say, there were 14 parties and they were all as bad as one another, so it's all right. But yeah. Anything else?
I've had a question.
You're right.
Is there a minimum monetary amount in dispute for parties to go in arbitration?
Minimum amount? Quite often it doesn't involve money. With arbitration, it's a much more flexible process. We do have powers to order specific performance. In other words, if you were looking at that, do you all know what specific performance is in a commercial transaction? That's where you can enforce a decision to say, this transaction has to be completed because it's been agreed to be completed, and if you don't, then the court will step in and sign the documents for you. That's an example of specific performance. In commercial arbitration, it could be, for example, a specific performance in respect of handing over the certificates of compliance. And so we have arbitrations sometimes where there's no monetary claim whatsoever. They're seeking an order that the work should have been carried out in a particular way. So that we'll go through to interpret almost like a declaration. And I've done quite a few of those over the years. So no monetary amount. Money is generally what it's all about. That's why I do it. So, thank you. Yep. That's all right, I'll come back to you. Yeah, we'll break if you like, because I want to move on to two other subjects after the break, and then at the end I'll take more questions, and then if you like, I know you're going to a tutorial later, but I'll be around if you want me to join you in any of your tutorials for a short while before I drive back to Sydney. So. Right, thank you all. We'll reconvene in about 10 minutes. Right, the next part we're going to talk about, a couple of people spoke to me during the break. If you do want to follow up on anything after the lecture, I'm quite happy to do so. We're going to move through the next two subjects fairly quickly. They're not terribly complicated if you know what it's about, but if you're new to it, it takes a bit of coming to grips with. The first thing is adjudication. Now, I'll talk about building and construction industry only because it's the most mature form of adjudication, and there's also something like about 450 court cases now that are run in various jurisdictions around Australia that I know of, which refer to adjudication or the application of the security of payments legislation in the building and construction industry. So it's quite mature from that point of view. But having said that, out of the 5,000 or so payment claims that we know of that have gone through, maybe a few more now, as I say, there's only about 450 cases that I know of, but that doesn't take into account court intervention in matters by the district court, which are unreported cases, and so I don't know what the stats are from there. But it has led to a fair bit of litigation, but not too much litigation when you consider the number of matters that are involved in adjudication. What adjudication is, it's not a consensual process. It's not something the parties agree to apply. For adjudication to apply in the building and construction industry, if the parties enter into a construction contract, and that could be an oral contract or it can be a written contract, then the Security of Payments Act, or the Building and Construction Industry Security of Payment Act, or the Building Construction Industry Payments Act, depending which jurisdiction you're in, will come into play automatically. So that at what it does, it has a number of implied terms one way or another in it, And for example, whether the contract provides for it or not, a party carrying out construction work or supplying related goods and services is entitled to a progress payment. And if the contract doesn't say when you're entitled to it and how often you're entitled to it and when you can make a claim, then the contract provides all those specific terms. And this all goes back originally to subcontractors and suppliers not getting paid, and then companies go into liquidation and then rising again under another name, and they wanted to cut all that out. So now what it is, if people are not making payments to somebody, and that could be right from the principal to the head contractor, or the head contractor to the designers, the principal to the designers, right down to the supplier for the toilet facilities on the site, if you like, or the waste disposal. So it operates at all levels. It's one piece of legislation in each of the jurisdictions, but it covers these multitude of matters. As I say, $107 million progress claim I've dealt with, and I've also then seen claims of $1,500. And yet your legislation is quite prescriptive. It's so prescriptive, it's the only legislation I know in the whole of Australia or anywhere else that says you do this, you've got this amount of time. No options, even the adjudicator cannot extend the time. For example, if we just used, say, Queensland as an example, because it's pretty good, easy to understand legislation, it's probably the longest act in Australia for the adjudication process. A party puts in a payment claim, claiming amount of money. All it has to do is say, this is a claim made under the Building and Construction Industry Payments Act. It then has to say the amount that we are claiming is $365,000. The work that we're claiming is this, and this made up as follows. And it might be all on one A4 sheet. It might be in, a simple fax to somebody. It may be in several boxes of documents, however the parties want to do it. That is a payment claim. That kicks the whole process off, as simple as that. The other party has 10, that's going on and off, is it, Doris, or not? Is that okay? The other party has 10 business days in which to respond to that claim and say, that's okay. If they're not going to take issue with it, then won't even respond because they're going to pay the whole amount. But if they don't respond within 10 business days, they become liable to pay whatever was claimed. And I've seen it where a contract is for $300,000, a claim comes in for $700,000, there is no response to the claim, and the court has said, well, you had the opportunity to respond, pay it, and then you can fight about it later. So if there's no payment schedule, this Act says you just got to pay whatever was claimed. So what is a payment schedule? A payment schedule, all it has to do, it's a document, a piece of paper, fax, whatever, it can be a single page, so refer to your claim dated 8th of August. The amount that we intend to pay is $25 or nothing, or you owe me $160,000, whatever it may be. And the reasons why I'm not paying your claim, or the reasons for the difference, are as follows, and you might set up a paragraph. It might be because I don't like you or what have you. You've got a reason for not paying. That is a payment schedule. And you see the most ridiculous payment schedule, and then you see the most clever ones, and then you see those that are very well targeted. But what happens is that generally most parties will put in an articulated, properly articulated claim, a properly articulated payment schedule, so the parties know what the problem is, and between the two of them they'll sort it out so that next month they'll get their payment. And quite often, somebody said, well, I'm not going to pay for your plumbing works until you give me the certificate from the department. And so they say, oh, if that's all your problem is, or I want a stat dec that you've paid your wages because the contract says you have to. Oh, okay, here's my stat dec. Okay, now that you've got it, we've resolved the problem, here's your payment. That's the whole intent of the Act. But it's a drop-dead piece of legislation. In Walter Constructions versus CPL Surrey Hills, for example, in 2003, the claimant there claimed $14.2 million, and they had said to the client, look, we know claims are due on the 25th of the month, but that's Christmas. We're all going on a Christmas party on the 18th. Can we drop our claim in on the 18th? And all this is in writing, so yes. So there was an agreed date for the claim. They put the claim into the principal and said we want $14.2 million. And they even admitted later that the claim was worth about $800,000, but they claimed the $14.2 million. They gave it to the superintendent as well, who had 28 days to assess it under the contract, not under the legislation. But the principal had an obligation under this legislation to give them a payment schedule within 10 business days and didn't do so. It just so happened that the principal looked at it when he got back from being on the boat trip on the harbour with the contractor, came back to his office, saw the claim on his desk, didn't know what a security of payments claim was. He said, oh, well, the superintendent always does the progress claims, won't worry about it. They all went on holidays. They came back at about the 15th of January or 18th of January, and at that stage the superintendent also came back, certified the payment for $300,000. The principal paid the $300,000, and within hours he was served an initiating process from the Supreme Court in Sydney seeking a declaration for the payment of the balance of $13.9 million on the basis that there was no payment schedule. Hey, bit of roguery, you'd reckon. Anyway, the court said, no, if you didn't want to pay it, all you had to do was provide a payment schedule. You didn't do it, pay the $13.9 million. And they even admitted to the court that a lot of this wouldn't have been referable to the Security of Payments Act. It was for damages claims and things like that, which were outside the jurisdiction of an adjudicator to deal with. So that's how drop-dead this legislation is, and it's just as bad or just as harsh, if you like, in every state in Australia. So if you're advising clients, you've got to consider a couple of things. A claimant cannot lose in the process. Just cannot lose. The worst result for a claimant in this process is they get a zero result. Now, I'm talking about all of the states of Australia except Northern Territory and Western Australia, who have better legislation than the other states, in my view, but it's a different process. There you can get a bum result. But here, you can't have costs awarded against you, and you also can't get a result worse than zero of your claimants. There's no downside. Also, if you're contemplating litigation, you've probably enhanced your prospect of discovering what the other party's arguments are and discovering documents that you wouldn't have got access to anyway. So it's a process that is open to abuse, if you like, and it is abused quite often. And also, because the nominating authorities, there are some private nominating authorities and there are not-for-profit organisations as well, there is a tension at the moment that goes on. A lot of people believe that there's a bias within the nominating authorities to nominate adjudicators who will be claimant-friendly. Now, whether that's factually correct or not doesn't matter. That's the perception that's spoken about. And the problem that's caused by the fact that only the claimant can choose the nominating authority. An adjudicator can only be appointed by a nominating authority. So it's in the interest, if you like, of adjudicators and nominating authorities to be friendly to claimants so that they keep coming back to them for the process. Because the nominating authorities in those cases take something like 30% of the adjudicator's fees for running the process. Well, they don't do that amount of work, so they're taking money for jam. So the process is still open to abuse, and you need to be aware of that. But if you're advising a claimant, it's really good to get to grips with the Act and the fact that even on a small construction job, it's a very, very good piece of litigation to get involved with. If you're a respondent or a principal in a matter, or if you're purchasing goods and services, then you need to know that you might be the recipient of a claim at some stage. You need to know that, number one, within 10 business days you must provide a payment schedule or you must pay the whole of the amount that's claimed by the due date for payment. So that's very, very important to know from there. There must be a construction contract for the whole lot to apply, and the construction contract is defined in the Act as a contract or other arrangement. So all that law that you learnt in contract law about what constitutes a contract, what are the elements of a contract and that would have to be proven if you were going to court or to arbitration, are not relevant. They could be. If they exist, then there is a construction contract. But for example, there can be arguments about legal capacity, all those sort of things. The adjudicator is not interested. They're only looking as to say, was there an arrangement between this party and that party, between the claimant and the respondent? If they say there was an arrangement there whereby one party was going to carry out construction work or supply related goods and service for the other party, then for the purpose of the Act, it's a construction contract. I've seen some doozies and I've seen some adjudicators find it on the most spurious of grounds. Having said that, it just means to say that you don't get into legal argument really too often about what is the construction contract. What the argument often centres around is who is the party to the contract. And that might be that, no, I don't have a contract with you, my brother had the contract with you, or my related company had a contract with you, or it was ABC Queensland, not ABC New South Wales Proprietary Limited that had the contract. So the process is, number one, there's a construction contract. There must also then be a valid payment claim, and as I told you, it doesn't take much to do it. There has to be a payment schedule for 2 avenues to adjudication, or you can also go to adjudication if there is no payment schedule, depending on how the timing works out. But the thing is that it goes through, if you do apply for adjudication, you go to a nominating authority and they refer the matter to an eligible person. Any of you could be eligible people if you want to become adjudicators. It's a very delightful field to work in, but a lot of pressure. And then once you accept, you've got 10 business days in which to make your decision. Right, so it's not a lot of time. If it's not a complicated matter, I've been speaking up until about 11:30 last night to an architect in South Australia, and she was getting her first decision out. She'd attended one of my training courses in South Australia earlier the year and passed. And she was frantic. And I said, Lolita, there's $17,000 in dispute here. How much time have you spent in it? And she said, 96 hours so far. I said, how much are you charging for? She said, about 5. So it really is. It's a lot of work involved in doing an adjudication, particularly when you're new to it. So if you do want to become an adjudicator, go and do the training, become an adjudicator, but then apply yourself carefully and do as many as you can, because you do get better at it. Anyway, what happens with an adjudication is that the adjudicator makes a decision, and the adjudicator decides only 3 things. They decide the amount of the payment to be made, they decide the due date for payment of that amount, and they decide the rate of interest that will apply on that adjudicated amount between the date when it was due and the date when it's to be paid. Now, the amount, whatever they determine, for example, in the Walter CPL case, Surrey Hills, had that gone to adjudication, it didn't, because there was no payment schedule and they went for an enforcement in the court. Had that gone to adjudication, the $13.9 million balance would have been payable in 5 business days. Now, even a government department has trouble coming up with that kind of money in 5 business days. It exceeds the budget, no allocation for it. You want to see the rollings that go on behind the scenes to comply with an adjudicator's award. If it's not paid within that time, you go back to the nominating authority and say, look, I've got an adjudicator's award here for $560,000. There's the award. I haven't been paid any of it. The nominating authority just fills in a form called an adjudication certificate, and then they sign it, and then you take it with an affidavit down to the court saying, here's the adjudication certificate. I haven't been paid any of this amount. The courts don't argue. The registrar just make sure you filled in the right forms and you paid your $44 or your $76 or whatever it may be, whatever jurisdiction is, and it's stamped as a judgment of the court. That's it. You've got a judgment against somebody, and all you've done is you've gone through this adjudication process. It's a real knockdown, drag-out piece of legislation, and it's something that, as lawyers, it will surprise you that governments around Australia could have passed this. When it first came in, I was surprised that the New South Wales government passed it, because it was the controlling body for the legislation was Department of Commerce, and who do you reckon would do most of the government contracts in New South Wales is Department of Commerce. So who would be one of the most frequent respondents in the whole process was Department of Commerce. But even though the legislation was against their interest, they endorsed it and pushed it through. I thought, well, they'll never sell it in the other states, but I'm wrong. They've got it in every state in Australia now, so it does. Now, the other thing is with payment schedules, if you don't provide a payment schedule complying with the Act and provide it within time, you're automatically liable for the amount that's claimed. But there's another thing that claimants can do. They can actually give a notice to the other party saying, well, look, you haven't paid me by the due date for payment, so here's my notice of intention to suspend work. So what that does, that brings the project to its knees. So what I'd commend to you is to have a close look at the legislation, and I'd like to take some questions from you on it later, but it is something which, if you're going to get out there into a lot of industries now, you're going to find that this type of legislation is going to be there, particularly in the building construction industry. It's already there. The mining industry, all their infrastructure is covered by, or most of it is covered by that same piece of legislation. Rail, roads, harbours, even cleaning contracts for buildings, maintenance contracts for buildings here in the ACT are covered by that legislation. So it's not just getting out there, it's not the hammer and nails type work or concreting or road building only, it's all of these associated things. It's the concrete supplier to a job. He can actually, he's associated, it's a related goods and service. The designer that does the project, the surveyor that's working on the job, they can all utilise this piece of legislation. So if you're going to work in any of those industries, you'll find that this is something you'll need to come to speed with. Yep.
Sorry, just wondering, since you mentioned that the fact that it wasn't going to, you didn't think it was going to take on, what was it designed to achieve? Did it have, was it supposed to right some sort of inequality that existed
Yes.
previously?
Yep. Just the question runs to why it was introduced. If you have a look at the object of the Act in each of the jurisdictions in Australia, it's essentially to ensure that people are entitled to progress payments, because a lot of contracts didn't provide for that. If you look at the second reading speech, say in New South Wales, Victoria, etc., Victoria's a little bit screwy, but essentially the same, what they're saying there, that it was to ensure cash flow in the construction industry, because the construction industry is notorious for having work done. You get invoice at the end of the month, you're entitled to payment at the end of the following month. So there you've got 2 months or 3 months work out of somebody, or somebody says, oh look, I can't pay you this month, Fred, I'm behind with the bricklayer, so I won't pay you as the concreter for now. Is it all right if you wait another month? So then you've got 4 months work out of this bloke, and you say, look, I can't pay you at all. By that stage you've gone bust, because you've got to pay your people and your suppliers for those 4 months. And that was endemic in the industry. In fact, there's another inquiry just completed last year by Bruce Collins, QC, into this construction industry. So the wrong that they were seeking to right was the cash flow issue and the trickle-down effect. So if the principal doesn't pay the head contractor, then the head contractor can't pay the subcontractor, the subcontractor can't pay the supplier, and supplier can't pay the brickie, and God knows what else. And that whole trickle-down effect is what it was supposed to cure. And that's why the legislation covers all claims. It doesn't matter whether it's the $1,500 claim for the week's work from a bricklayer. You won't get a bricklayer for $1,500 now. That was his meal allowance. That'll be the $1,500 for the tradesman, or whether it's $15 million for the head contractor. That'll be, that legislation covers that whole lot, because when he gets paid, you get paid, etc. What the Act also does, it outlaws provisions in contracts. For example, it's now illegal to put into a construction contract that you will get paid when I get paid, or you'll get paid if I get paid. And quite often what happens is that a carpenter has a contract, it might be for $100,000 to do the work, and then the contractor says to him, look, we want you to do 2 extra units. And he says, oh, well, that'll be $140,000. Oh, look, I'm not sure it's a variation. Yes, it's a variation, it's 2 extra units. And so they have a bit of argy-bargy. And so the old deal was that if I get paid from my client, I'll make sure you get your $40,000. That is now illegal, to have that paid if paid or pay when paid. The Act also provides that you can't contract out of the Act. So they're the sort of wrongs that it was seeking to redress. The second reading speech was actually Maurice Yemmer at the time, was the Minister for Works and Services, who went on to be the New South Wales Premier, but he was the one who introduced the bill in his second reading speech, which I can send you or give to Doris if you want to. Tells you all about this legislation, how it works, etc. It's only a short speech, but very much targeted, and it has worked the way that he said it would work.
Did it swing the other way too much?
Yes.
So now,
Quite frankly, I mean, politicians don't answer questions like that, do they? But yes, it has swung too far the other way.
so now the respondents are in need of kind of remedy against the bill?
Probably what they need is the legislation. Either the legislation grows out of the legislation in the UK, which is the Housing Grants Regeneration Act, and there, principals or contractors, or the people who we call respondents in New South Wales, they can actually initiate the process. So you can actually claim against a contractor for doing shoddy work, for example, or you could claim against the engineer for a bad design or a faulty design. You could claim, for example, where there'd been an overpayment, where somebody had overclaimed and somebody had accidentally slipped it through and paid them $100,000 too much. So you can actually have claims from both parties, either one. So I think that needs to come in. Secondly, I think we've got to correct our problem with nominating authorities. In other words, the private bodies, I think, have to be taken out of the system because there's an inbuilt apprehension of bias, whether it's real or not. It's a perception some people have, not one that I necessarily share. I don't do work for any private bodies, but I know a lot of other adjudicators who do, and I think they give it an honest approach. But I know that people think they're not giving it an honest approach because of the money involved. So they're the sort of things that it goes the wrong way. I think there are simple ways of curing that. For example, you could have in your contractor agreement, you could have it that you have 3 nominating authorities named and the claimant can choose from any one of those. Well, a respondent's not going to put into the contract nominating authorities who are perceived to be claimant friendly. By the same token, if there are a lot of respondent friendly bodies, then you might find this pendulum goes back the other way. There'll always be that tension, doesn't matter what you do, but I think there needs to be a lot done to correct the process. But live with it the way it is at the moment. It can work for you or against you. Those who know how the Act works, it does work very well for them. All right, I'll just move on quickly to another process, and it's not really a process, but it's a concept which has been developing, and it's probably been running now roughly 15, 20 years around the world, and it's the concept or the practice of dispute boards. They're sometimes called dispute boards, sometimes they're called dispute avoidance boards, and they're sometimes called dispute resolution boards. DRBs, DABs, DBs, they're the terms that you could hear you bandy around. In most cases, they were restricted to, and generally still are, applied on large and complex projects, such as big civil engineering road projects. The one for Kiribati that's coming up the next week, I think it's around about $10 million, so it's not a big job. It's, in terms of civil engineering job, it might be $15 million. But there's also, like the New South Wales desalination plant for $1.8 billion, $1 billion there. The Victorian desalination plant had a dispute board in it. I think that's $1.8 billion. The big rail jobs in Sydney and they have dispute boards on them. I'm on the dispute board for the NBN, a lot of fun. What the whole idea is there is that we have a standing board. In those cases, there are 3 people. Other smaller projects, we have a 1-person dispute board. But the 3 of us meet with the parties every 2 or 3 months. In all the time, in the meantime, they feed through to us the minutes and reports and everything that's going on the project. So we're fully appraised and we're paid to keep appraised of what's going on the project, so that at any time anybody clicks their fingers, we have to be able to step in and do something about it. And what happens is that when we meet every 3 months, we have an agenda where we identify all those things that are still bubbling away that we see, well, why has that not been resolved? Is this an issue? We see there that you haven't been able to settle the construction program, or the design for the stabling of the trains is not yet complete. A little note in the report says this has been holding us up for 2 months, and then the report in the next month's been holding us up for 3 months. And the dispute board will just say to the parties, well, what are we doing about the stabling? Is that being resolved or what have you? And some parties will say, oh, look, it's not really an issue, it's just the way it appears in the report. We'll get it out of the report. But if it is an issue, then let's address it and we will discuss it. Quite often it's resolved there and then through the discussion. If it's something where the parties have completely different views on it, and that's the problem, rather than just maybe not having the resources to get up there and complete the design or get the approval done, if it's a genuine dispute about the obligation or something, the parties will say to the dispute board, can we have a preliminary non-binding opinion from the board? And we'll say, yes, well, tell us your position, and then we'll sit down, and between the 3 of us, we'll say, well, our preliminary view is you have the obligation here to provide that, and you have the obligation to pay in accordance with this. And quite often, in most cases, the parties live with that because they really don't want to go through the rigmarole, if you like, of make it a more formal. But if they don't like our preliminary non-binding opinion, they then ask us for a decision. And in that process, we have protocols set out where they make submissions from both parties, and we can actually conduct a conference with them and get further information, etc. We can go onto the job and make our own inquiries. But we must make a decision in accordance with the contract of the parties, and we say, look, the position, and we might be totally contrary to our non-binding opinion because we now know a lot more about it. Here's our decision. Now, the parties have to comply with that decision, no matter how bad or onerous it is for them. They must comply with it. They can challenge it, but they still must comply with it. So we might say, look, you've got to do this, and the amount that's going to have to be paid is that. Now, in the meantime, the contractor has to do that, and the principal has to pay that amount of money. They can go and challenge it and get it righted later through a court, but they must initiate that process within a set number of days, depending on how the dispute board's set up. Now, a number of variations you can do to this process, depending on how you do it and what protocols you want and the type of job that it is. It's very flexible when you set it up, and then you move with the times. And sometimes you will meet every few weeks for a while, particularly when things are really developing rapidly on a job. Like another dispute board I sit on is the Inner West Light Rail project in Sydney. Now that project, I think at this stage, there's arguments about when the completion date will be, etc., but it's something like a year ahead of schedule now, as far as I understand. So they're still arguing they want it quicker, but they're still saying, great, they've resolved most of their problems along the way. Now, there will be some issues to deal with at the end of the day, but that's not a problem. In all of the dispute boards that have been around Australia, I think there's 44 up to August that I know of since 1987 that are on record. But it's really a little later than that they started to get underway. But 44 since then. There's another 35 in the pipeline still to be signed up that we know of. And of course, they're not always disclosed to everybody. It's a private process. There have been a number of informal dispute procedures. There have been a number of more formal dispute procedures, but not totally formal. Those disputes on those projects, out of 44 of them, since 1987, mind you, there's been 8 knockdown, drag-out disputes dealt with by dispute boards, right, out of 44 dispute boards. And the number of disputes not resolved through the DRB process to date is nil, every one of them. And we're talking about roughly, I don't know, I did have a figure there for it, but we're talking, I haven't got a figure, but you're talking about billions and billions and billions of dollars of projects here where ordinarily the litigation would have been as fierce as the construction activity. And that was the nature of the construction game. So they do work. They work provided that the parties have an open mind when they enter into it, and provided you've got experienced DRB people. One of our problems with experienced DRB people, you can imagine with only 44 DRBs in Australia, so far, we don't have too many experienced people. We have, at this stage, I think we have 140 people trained to do this, but a lot of people are either conflicted out, because once you've been in the industry for a while, you find that, okay, I've had too much dealings with that designer and too much with this superintendent. I've worked for that department, I've worked for that in this industry. So conflicts are a big thing in trying to put a dispute board together, conflicts of interest or apprehension of bias. And the other problem that is there is availability. If you wanted to commit, one of the dispute boards that I got appointed to was for 7 years, and I'm no spring chicken, so I have to say, well, okay, do I commit for another 7 years? So they're the sort of things that are available. And a lot of us have got grey hair. We need some young people who can take the mantle and run with it. And because hopefully you'll be around for 7 years, even if I'm not. With the dispute board availability, it's sometimes difficult to get 3 people who are going to be able to do it. And one for Papua New Guinea that I was invited for recently, as to go onto a panel of 3 people, so it would be a 1-person DAB, but selected by the contractor, the government of New Guinea. They put me onto that selection panel of 3, and there was 1 from England and 2 from Australia from there, and the contractor was from Korea. And he thought, oh no, we're too closely aligned with Papua New Guinea, so we'll pick the bloke from England. So he flies out about once a month now to meet in New Guinea with the contractor and the Papua New Guinea government to keep that project running. So again, it would have been nice if we had somebody a bit closer and availability of people is a problem for it. But once you've got the dispute board constituted properly by the right people, they work very, very well. The idea originated in the United States, and it's been adopted very heavily over there. In fact, all the road infrastructure projects in the United States of any size, by all of the states within the United States, use dispute boards very heavily. Queensland and New South Wales use them quite a lot. You find, like, for example, there's a couple of dispute boards coming up for the Bruce Highway, Cooroy to Curra, Pacific Motor Upgrade, Townsville Wastewater Project, Gateway Arterial Upgrade. They're the sort of projects that have been used up there. Victoria only has had, as far as I'm aware, about 3 so far. New South Wales had quite a lot. The thing that happens with the dispute boards, when it's set up, generally the dispute board agreement is signed the same day as the contract between the parties, so it's there right from day one. And it's important to get in early. You can retrofit them to a project, but generally then the dispute board has to come up to speed, and by that stage a lot of things are already a problem, and you've got to go back and resolve, go back to square one, and a lot of stuff started again. They start with operating procedures and protocols that are agreed between the parties and the dispute board right at the beginning, and then quite often once the dispute board is appointed, before the first meeting they'll have a rethink amongst themselves as to how those operating procedures could be better or the protocols could be changed. And in all cases I know where we've put that to the parties, that we think that your protocols or your procedures are just going to create problems here or not run as well. It's a very sensible process. And in all cases that I know of, or been involved with, the ones that I've been chairing, the parties agree to those changes and they incorporate it into a formal deed. The thing is that the whole process, except the formal dispute resolution, is without prejudice. So you can say what you like, do what you like, providing it's honest and meet those sort of things, but it doesn't go outside the parties. So the parties are quite free to resolve things, and they'll sometimes have a meeting in the morning through their their project control group or project leadership team, and they'll go hammer and tongs in there and not tell each other really about what the real issues are. They break for coffee, and then we will start our dispute board meeting, and the discussion with us is entirely different to the discussion they had in the other meeting, because the other meeting is minuted, everything is with prejudice, and it'll be held against them at the end of the day. They come into our meeting, we minuted everything else, but it's all done on a without prejudice basis. Now, we quite often sit in on the project leadership group, and we think, okay, gee, they'll never resolve that. They're so far apart. Come into our meeting with only half an hour apart, and it's all right. No, well, gee, look, we know we should have put that in on time. We didn't, so we did this and all the rest. Well, why didn't you bloody well tell us? But you couldn't do it there because that would be an admission on the record, and if there was a legal battle coming later, that's where it'll be. So that's why they tend to work well, because the parties are open and honest with each other in these processes. We can look for novel approaches. We can give them solutions they can live with in the meantime, and they can just get on with the project. So they don't have this idea where you have a Mexican stand up and say, look, I'm not going to construct that. That's going to cost me too much money. I don't think I have the obligation. The other party says, well, you do. And they end up with terminated contracts and all sorts of things. What happens where you've got a dispute board? Like the Millennium Trains, you have 2 big train projects, the Oz Train and the Millennium Train in New South Wales. One of those projects has a dispute board, one doesn't. I think one was $600 million to $1 billion over budget, and I think it was 2.5 years over budget, and all sorts of performance requirements where the trains just didn't meet the specification. The other project has a dispute board running similar sort of parameters and contracts and everything else, but with a dispute board. There have been no disputes. There's been no cost overrun, and it's ahead of the contract schedule. And it's because of the different approach, the different attitude of the parties, and it's generated, in part, there could be other reasons as well, but it's also generated because the parties have this cooperative approach to contracting. So you'll hear terms like cooperative contracting. I could commend that to you if you're getting into alternative dispute resolution. There's all sorts of fields out there. They don't work for everybody. They don't work for every project. They don't work for all parties. It is up to you, as being the legal advisors or assisting in the process, to know what processes are out there, whether a conciliation might work, an expert determination, a mediation, arbitration, adjudication, the good side, the bad side to each of those, the likely costs, what the parameters are, so that you can advise your parties accordingly. And also just keep an eye on the future. It might be a career that you would enjoy as much as I do. It'd be very difficult to beat how much I enjoy it, but you might do. So, questions before we close? Yep.
With the dispute boards, that's something that the parties choose to contract into their
Yes.
agreement. There's no legislation
No.
at this moment in Australia
No.
requiring it.
Purely consensual?
Would you recommend it?
Yes. If nearly every project, anything from about 20 million upwards, I think that you would be mad not to consider it.
Is it on the cards?
Yeah, but they won't legislate for it. It'll still be up to the parties to use it if they wish. Some people are still afraid of it because they feel they're losing control. But the thing with dispute boards is that the way that it works to choose your board is that each party nominates one person. They generally, what they do is one party will nominate 3 or 4 and say, take your pick. And the other party will say, well, I'll pick one of those. And then the other party nominates 3 or 4 people and somebody will choose out of that. And then those 2 dispute board members then appoint a third party. They won't pick somebody that the other parties have failed to agree on unless they go back and say, listen, we reckon Graham Peck is still the best bloke for this job. Why don't you do it? They might ask the parties in that case, they say, okay, we'll agree to Graham Peck. Or the dispute board will then pick somebody entirely neutral that hasn't been the subject of discussion before. But that's how the board gets constituted. And then that dispute board then elects one of their members as the chair of the dispute board. Thanks, Doris. Thank you, everybody.